More and more employment discrimination cases are getting past summary judgment and to trial. Too often, the defense focuses on what the company did or didn't do, and this is a strategy that plays right into plaintiff's counsel's hands. The more the jurors talk about the company's actions or inactions, the more opportunity for them to find fault. A winning strategy requires the defense to change the narrative in subtle and respectful ways, leading the jury to focus instead on the plaintiff's conduct. Here to help us learn about the winning strategy in employment discrimination cases is Blake Marks-Dias from Corr Cronin in Seattle, Washington. Blake.
Good morning. Employment defense lawyers get to represent great companies. We like our clients. Often they have good written policies. Sometimes we help to write those policies. So the temptation at trial is to tell a story that focuses on what the company did and how the company acted reasonable. And that can be a big mistake, and here's why. Because jurors have a tendency to critique what you put in front of them. And if the plaintiff's counsel has succeeded in creating a sense of sympathy and unfair treatment, then a story that concentrates on what the company did or didn't do won't be persuasive to them. You've got to show that evidence, of course, at trial, but in a secondary way. During the deliberations, you want the jury talking about the plaintiff and mistakes they might have made and reasons why the allegations may not be true, alternative reasons why they may be making the allegations. You don't want the jury talking about the company's investigation. That's not going to work. If they sympathize with the plaintiff, it's going to be seen as an after-the-fact rationalization. So we've heard about the general decline of civil jury trials, and employment cases are a modest exception to that trend. They're still going to trial. And there are several reasons for this. Starting in the 1990s, there were amendments to various civil rights laws, but also these cases are very fact-intensive, and they can escape summary judgment. During deposition and in interrogatory answers, the plaintiff's going to put forward perhaps dozens of allegations of remarks and slights and mistreatment, and each one of these things can become a rabbit hole that you go down, and there's conflicting testimony. And the sense in the employment bar in Washington, at least, is that summary judgment is getting harder and harder to get. Other reasons why these cases go to trial more often than a normal commercial dispute are that it's personal, and not just for the plaintiff employee, but also for the company and its management. They take these cases very personal as well. There's also a disparate risk. Sometimes you've got a plaintiff that just feels like, I've got nothing to lose. I want to go to trial. The plaintiff's lawyer who's working on a contingent fee's got plenty to lose, but sometimes they lose control of their client. Other times, plaintiff's lawyers have a sense that they've got to take a certain percentage of their cases to trial just to maintain credibility, and so that the companies aren't calling their bluff all the time at mediation. So those are some of the reasons these cases still go to trial. There are also remedial fee-shifting statutes at issue in these cases, so if the plaintiff loses, that's it. They don't pay the company's fees. But if the company loses, they pay the plaintiff's fees and much more. And unlike in a typical commercial dispute, there's a great lack of parity with respect to discovery burdens. The plaintiff can push and push and push for more and more electronic discovery, depositions of company witnesses without any fear that they're going to have to respond to in-kind demands from the company, because in an employment case, the plaintiff has very few documents and the company's got a ton of documents. So it's a one-way street, and the plaintiff can push for that and exploit it. And in that instance, some companies decide to settle early just to avoid the discovery burdens. And others don't play that game, and they're prepared to take it all the way. And I see that especially with some of my larger clients who get hit all the time by what they might call a frequent flyer plaintiff's lawyer. And they've had enough, and in the right case, they're prepared to go the distance to take the case to trial. For whatever reason, a lot of these cases 25 years ago were tried to the bench, and now the majority of them are actually jury trials. So now that we've talked about employment cases are still going to trial, and I think will remain that way, I want to talk about the importance of the narrative in these cases. And narrative's important in any kind of case, but that's especially true in an employment case because these cases involve real human drama, people doing things in the workplace. And the jurors either are in the workplace right now or they have been at some point in their lives, and they're going to compare what they're hearing with their own personal experiences in the workplace. And you can exploit that to your advantage because you want them to be comparing themselves to the plaintiff, but not thinking about how the employer could have done things better. The power of narrative. So chronologies and linear facts are helpful and important, but it's really the story that counts. And this is deeply ingrained in our brains. It goes all the way back to human beings sitting around the fire and listening to the story. Facts may either be accepted or ignored or rejected, depending on how they fit into the story. Even jury instructions contribute to this paradigm. The judge tells the jury to consider the evidence in light of your ordinary life experiences and common sense. Social scientists who study juries have concluded that they interpret information not by analyzing each relevant piece of evidence in turn in a linear sense, but instead by constructing competing narratives and then deciding for themselves which story they find more persuasive. Here's a kind of anecdotal phenomenon that supports this theory that juries and judges often don't reach the same conclusion. So there was a Northwestern University study. They looked at about 400 cases, and they compared the jury verdict with something that they had asked the judges to fill out a questionnaire stating what they felt like would be the proper verdict in that case. And the juries and the judges disagreed a quarter of the time. So I think what that shows is that juries don't always examine the evidence in the way that we lawyers might expect them to. This was an apt quote from Barbara Hardy. If you think back to something like your first crush, for example, I suspect that memory of your first crush is going to be a lot more story-like and narrative-like than something like a boring chronology of events that you might see on a trial exhibit. You know, like I went to class in the 5th grade and she was, you know, it's just not going to be a chronology. It's going to be much more story-like. That's just how we think. All right, so I know this is old hat or old glove, perhaps, but the OJ trial made a big impression on me because it was happening right before and during my first year of law school. And so I was really excited about it, and I was glued and watched the thing. So it made a big impression on me. And then it was recently brought back into pop culture with a TV series that some of you may have seen. And by the way, if they gave out an Oscar for overacting, I think John Travolta would have won that running away. Also, I don't remember Robert Shapiro being smaller than, or being larger than O.J. Simpson in real life, but I'm not a casting director. But anyway, the case is not an employment law case, obviously, but it is really instructive for narrative because in the O.J. trial, the prosecution had a ton of evidence and facts. There's no question they had a ton of that. What they lacked was a cohesive story. And the defense story was simple. There was a rush to judgment, right? They said there was a rush to judgment, there was a bad investigation. And they were able to shift the narrative away from O.J. Simpson and onto the LAPD and the investigation. And I acknowledge there was a lot going on with this trial in terms of the LAPD and the broader social issues, but undeniably one of the things that the jury was allowed to do was to critique what was put in front of them, and that was the LAPD. The pentad of a story. This is a structure that was put forward by Kenneth Burke, and he says that any well-formed story has these 5 parts. So some examples from classic literature, one would be Frankenstein. We've got Dr. Frankenstein, he's the actor in the story. He goes to university and he works hard, devoting himself to the goal of creating life. And the project comes to a head in the scene where he creates his monster, and then trouble ensues when the monster begins murdering his loved ones. Another example would be Romeo and Juliet. Juliet's the actor in that story. She gets a sleeping potion to fake her own death. Her goal is to avoid a marriage to Paris so she can be with Romeo, her true love. Her message doesn't get to Romeo, and trouble ensues when she awakens and he doesn't. She stabs herself with his dagger. These are classic stories. They've got a pentad. Employment cases aren't nearly as macabre as classic literature, but in employment trials, often the plaintiff will tell a story about the employer as the actor, and the employer's goal is to make money and to justify its actions, and the employer's actions cause trouble for the plaintiff in the form of unfair treatment, which must be compensated. So let's talk about how to build a narrative that focuses on the plaintiff's conduct and where the plaintiff is the actor in the story and not the company. And a reminder that the reason we're doing this is because jurors have a tendency to pick things apart. They will critique what's put before them, so you want them critiquing the plaintiff's conduct and not the company's. Jurors relate things to their own lives. I think it satisfies one's ego to think about how one would have done something better or different than someone else. So for example, if you're telling the jury about how great the company's investigation was, chances are at least some of the jurors are already saying to themselves, I don't know, I would have interviewed these other witnesses, I would have issued a harsher reprimand to this person, I would have done this or that. So instead, what you want the jurors to do is to say, I would never have done that about things that the plaintiff was doing, not things that the company was doing. There are some powerful obstacles to changing the narrative in any kind of case from the defense perspective. There are several things that come together to make it very difficult to change the narrative, and the pitfall is reacting rather than playing offense and creating your own story. One of the obstacles is public perception. There are a lot of articles about unfair business practices. These are just a few examples. Sometimes there's articles about great companies and the great things that they do, but that's kind of the exception, and what the public seems to glom onto is the negative stuff. Also, another obstacle is that the plaintiff is the first to frame the issues. They do have the burden of proof at trial, but they get to go first, which is a tremendous advantage. They get to go first in voir dire, in opening, and in closing. But perhaps more importantly, they get to decide which witnesses you will see and hear first. And that is a powerful tool. In my experience, savvy plaintiffs' counsel are putting on more and more company witnesses in their own case. And this is partially so that they can control the first impression of those witnesses. They put the really icky stuff about those witnesses out there first, so that's the juror's first impression of your great company witnesses. In a perfect world, you would get to make the first impression with those witnesses by putting them on in your case, and then that would be the juror's first impression of them. They take that away from you by putting them on in their case. But another reason that they're doing this is because they're constructing a narrative in their case about the company is the actor and the company's conduct, and the company is causing trouble for the plaintiff. So there's a dual purpose in why they're doing that. Now, the defense advantage at trial is that the plaintiff does have the burden of proof. And it's possible to win a case just by poking holes in the plaintiff's story, even when those holes themselves don't tell a coherent story about what did happen. But for both sides, the most compelling case is going to be one that tells a good story. Another problem is that the initial information, which is put forward by the plaintiff because of the structure of trial, can become sticky and making it difficult to undo. And cognitive research has shown that it takes much more effort to engage and undo these sticky issues. And so you need a powerful tool to unstick those issues, and a clear defense narrative is such a tool. Jury instructions can sometimes also be an obstacle to shifting in the narrative in the way that I'm talking about. The jury instructions in the law often cast the employer as the actor. This is the typical disparate treatment claim instruction, and it's all about what the defendant did. Affirmative defense instructions are the same way, where they cast the defense or the employer as the actor. So how do we shift the focus without being a big bully? At the start of trial, the jurors are likely to kind of want to sympathize with the plaintiff. People like the underdog. At the beginning of the case, I think the hierarchy in the courtroom likely is the judge and her court staff, and then the witnesses, and then the plaintiff, and then the defendant, and we know who's at the very bottom, right, the attorneys. And this hierarchy can change and does change throughout trial, but that's probably your starting point. So instead of coming out of the gate with a story about the employer who had great policies and procedures and handled the investigation so appropriately, try to make it a case where the plaintiff is the actor in the story. Some themes that help make this possible, assuming you have the evidence to support it, are that the plaintiff wants to avoid responsibility, the plaintiff is making excuses for poor performance, or the plaintiff has some ulterior motive for making the allegations. But you can't just tell the jurors this, you've got to show them. Coworkers can be an incredibly valuable tool. Chances are the jurors are going to accept what the coworkers have to say more than the management witnesses, and definitely more than what you as a lawyer are telling them. This was really helpful for me in a difficult employment discrimination case a couple of years ago. The plaintiff had a really simple story. He was called names all the time in the workplace, and because of his race and religion, and the company didn't do enough to stop it. So the defense narrative could have been all about how great my client's policies were, how robust the investigation was, how it issued reprimands, and how he didn't avail himself of all their policies and procedures. We showed all of that, of course, because it was true and because it is necessary to the law, but it wasn't our primary story. Instead, we cast the plaintiff as the actor in the story. It turned out through our investigation that he was a class clown type who liked to joke around. The horrible name that people were calling him, Ahmed the terrorist, it turns out was from a Jeff Dunham character. And most of his coworkers said, yeah, I called him that, but I had never even heard that name before he was using it. It turned out that he was calling other people names. It turned out that he would disappear for hours at a time. It turned out he was caught falling asleep when he should have been working. And I guess that would have been a good time for the George Costanza nap Seinfeld slide, now that I think about it. And it also turned out that every time he went to HR to complain about something, it seemed to be right after he was in trouble for doing something. He was getting some reprimand for sleeping on the job and what have you. So instead of a case about, my client and all its great policies and how it handled the investigation, it was really a case about a funny but unproductive employee who wasn't accountable, and every time he got in trouble for something, he tried to transform his own banter into a discrimination complaint. Earlier I talked about jury instructions that are obstacles to shifting the narrative. Some instructions actually enable you to do this. This is the standard harassment instruction, and particularly that part about the plaintiff needing to prove that he or she didn't solicit or incite the harassment was very helpful in the case that I just talked about. So a good narrative is important for success at any trial, but no matter how good your story is, it must ring true. And that requires having the facts to support it. So you need credible written evidence, you need credible testimony, you need credible storytellers who can present the story for you. That also has the benefit of personalizing the case, so it can become Janet's decision to terminate Jane rather than the company's decision to terminate Jane. This also requires really comprehensive pretrial interviews and investigation. I talked about those rabbit holes with all the anecdotal slights and stray remarks. Sometimes those yield gold in the form of coworkers who aren't aligned with the plaintiff and can help you tell your story about the plaintiff's faults and things that you want the jury talking about where the plaintiff is the actor in the story. Written evidence is also more valuable than just testimony alone. And so if you are going to cast the plaintiff as the actor in the story and call them a poor performer, you better have contemporaneous written reviews to back that up. Otherwise, the narrative's going to backfire and it's going to be seen as victim blaming. So proper documentation of the plaintiff's conduct in the workplace, way before the lawsuit starts, is not just a good business practice, it's also an essential risk management tool and a building block for being able to create a story where the plaintiff is the actor. Thank you.